Welcome back to another episode of Debatable with your hosts, Nina and Kyle. I'm Nina.
I'm Kyle. What's up, Nina? It's been how many weeks has it been? Like
A while.
it's been a while since our last episode, and we've been busy. Like the first week we didn't post anything. It was because you were angry at some things that we are not allowed to mention for professional reasons. But the second week we weren't able to post anything because I was busy with the Philippine Law Debate Championship. I
Mm.
was Adjcore, and Nina was also there, just providing moral support.
And then we weren't able to post after that again. Actually, this is the post.
This
for
is
this
that
week.
post, yeah.
It's a little late, but better late than never posting ever again.
Yes. Very late then going like, oh, we're relaunching the podcast
For the
for
second-
2 weeks
Yes.
and then goodbye.
Yeah, so for today's episode, we wanted to do a bit of a reflection on the tournament that Kyle, some Adcore worked for. Because honestly, it's a world I'm not very familiar with. It's debate, yes, but it's a subsection of debate that I am not well versed in. And it's the subject of law. And it's very fascinating to me to see law students and future lawyers get into the sport of debate. And it's a lot of overlap. But I really noticed that the style, the way that people discuss things, the emphasis that is placed on arguments varies quite significantly from the debating I'm used to. So we decided that it would be a perfect time for Kyle to inform me and you more about this world. And this works if you ever have an intention of joining law school or pursuing debate, even when you are studying law. So, if you don't mind, I would like to ask you some questions.
What's up? Let's go.
Okay. I guess the first thing that I'm really curious about is what makes law debates very different from regular debating or the debating you've been used to since you were a kid?
Well, legal basis is a
Mm.
thing, right? It's basically just the way you need to have an argument, you need to have examples that back up whatever it is that you're saying. But at the same time, you have to also argue about it from a legal perspective. And so you can say that whatever policy you're defending is a natural extension of a law that we already have, or why is it important for us to defend the Constitution, for example? And those things actually did come up in PLDC last weekend, right? This was last weekend.
Time is a blur.
Yeah, so that's mainly it, right? Instead of just examples about this is what's happening in the real world, you need to have some legal basis for whatever it is. So you can be quite general about it. Oh, we have this principle of stare decisis, which is the idea of we are bound by precedent even if we don't really agree with it. And the reason for that is you want to have a more stable and predictable judicial system, or you can be more specific about it where you go like, oh, under article 3 section 1 of the Constitution, you have your right to due process and equal protection of the law. So that's the main difference, I think. You need to have legal basis. You need to think like a lawyer a little bit, where you have a theory of law as applied to a particular situation, or you have a theory for why the law is like this and you want to extend or limit it towards a new policy. Because there are two kinds of law debates. One, as far as, sorry, this is my opinion. In my opinion, there are two kinds of law debates. One is how do we apply the law to a particular situation? And the second one is how do we change the law or do we create a new law, stuff like that. So the first one, how do you apply the law? The debate there is about how do we interpret the law, basically.
Is this like the freedom of speech, religion debate that you judged?
Yeah, it could be,
Mm.
right? So I said a motion about drag performers who incorporate religious elements into their performances and whether or not that should be considered part of freedom of religion. So that is a question about how do we apply the law of freedom of religion, as opposed to like, should we consider this freedom of religion, right? So it's not really about extending it or limiting it. It's about right now with what we have, do we say that it's already part of freedom of religion? Yes.
So I have two questions based on what you said. The first is, does it become harder to debate motions now in a law debate because you are bound by like legal basis and having to cite things, or do you think there is still a lot of wiggle room to experiment and run like wild ideas like we see in regular tournaments?
First of all, I would say actually, my first response to that is it depends on the tournament that you're in. Because some tournaments are more strict with the format, some tournaments are more strict with what you can and can't say. So, for example, we used a modified Oregon Oxford format, and Oregon Oxford unmodified typically has three speakers on each side, and the first speaker talks about necessity, the second speaker talks about beneficiality, and the third speaker talks about practicability. There are some judges in some tournaments, if you're a first speaker and you talk about benefits instead of necessity, you're not going to get a good score. But in PLDC, we did not use that rule. We wanted to say that, okay, sometimes the necessity issue goes all the way till the end. So we need to have that leeway or that freedom to talk about the issues that matter for that particular debate. So it really depends on the format that you're in or the policies of the tournament itself. But secondly, as to is it harder, it also depends on the motions, right? So as I mentioned, there are two kinds. So if you are not prepared, you don't have any research, and then you have something that requires you to know a lot already about the jurisprudence or the laws that are involved, you're going to have a hard time. And perhaps that is the reason why in many of these law debates, they typically request, hey, can you give us the motions a week to a month in advance?
No, similar to what they do in Mood. But Mood is like more long term, right? Like a year sometimes.
Well, not always, right? So some of them is like just a few months, and some of them can be up to like half a year.
Hmm.
But the issue with moot is in debate, every round you have a different topic. In moot, it's like the entire tournament, you have several rounds, but it's still the same topic.
So it's very similar to public forum if you've ever tried it. Like it's a topic given to you in advance. You spend all your time researching, creating packets and researching for that. And then that's the only thing you discuss. And what will change is the side you're on. Does that also happen in Mood?
Yes,
Okay.
but what I would say is quite unique about Moot is if you don't like info slides in parliamentary debate, you might not like Moot because the first thing that they do in Moot is that they give you a very long packet, and that's just the problem, right? So you can have like a 5, 10, 15 pages of just like, okay, here are the countries involved, here's what's happening, here's the timeline, here's the map, here's the illustration of their flag. Yeah, and it's quite interesting.
It's like an entire world being
Yes.
built, right?
Yeah. So I remember I saw one where it was like a territory dispute or something, and they had like an entire map, and there are different regions and stuff, and they
Oh.
were even describing like, okay, so this is a conflict between an armed non-state actor or an ANSA, and what essentially happens is like they fight all year round, but during the winter months, a lot of the foreign fighters go back home. And I'm just like, oh, what an interesting detail to put in this particular problem. So there, that's one thing that's different with moot. Another thing that's different with moot is I mentioned that there are two kinds of law debates, right? One is that's something that's more traditional to the parliamentary debate where, okay, this is what the law should be. And the other one is how do you apply the law? Moot court, moot problems are all about the second one. How do you apply the law? And there are lots of ambiguities with it. So one very important one is how do you determine whether someone is a combatant? How do you determine if someone is taking a quote unquote direct part in the hostilities during an armed conflict? Because one of the topics that came up a few years ago was the armed non state actor was training like their indigenous eagles to intercept like the drones that were being sent by the state party to the conflict, and they would tie bombs to the eagles, so they became like suicide bomber eagles. So obviously the eagles are taking a direct part in the hostilities, but like no one cares about the eagles. They're just they're animals. You should protect them, but you can't like, you are gonna go to jail, eagle. It was more about the fact that while the eagles are being trained, there are a bunch of children who had to feed the eagles every single day or something like that, or sort of assist in the training. So the question was, would you consider those children as combatants? Are they taking a direct part in the hostilities? Because if they are, not only can you kill them kids because they're combatants, but also the armed non-state actor has committed the war crime of employing child soldiers. So those ambiguities in the law, in international law and treaties or whatever, they blow it up. And that's the issue that we have to talk about. Like, okay, so how do we determine what this particular piece of international law means? And this is where a lot of research goes into it. You can look at what happens at the UN General Assembly. Did they ever talk about it? About state practice? Did other states do this before? And stuff like that.
Huh. That is fascinating. Do you think there are videos of that? I kind of want to. Now I'm very curious.
The Red Cross one, I'm not sure, but I can try to look for the problem there because it's quite interesting. There's also something about like the red diamond, which is like a non-sectarian. I'm not sure what religion it is or if it's a secular thing, but like you have the Red Cross, right? You have the Red Crescent. And both of them, if you see them on the battlefield, you can't just shoot them because they're medical personnel. So, in general, during a time of armed conflict, whether that's international or internal, only combatants can be attacked. Military personnel can be attacked, except for medical and religious personnel. Yeah, so in that problem, there was also like in the mist or something, you shot someone and then turns out they're wearing that red diamond.
So is it like the same problem? So does Moot talk about broad situations and then you have to find issues, or is it like hyper specific most times?
Well, it's a hyper specific issue where it's like, okay, 53 things happened.
Mm.
So from these 53 things, can you make a case that this person has committed a war crime? Or can you make a case that this person violated a particular piece of international law?
I see. So I guess the second question I have is, as someone who was part of the Edge Corps, right? What's very different with setting motions or deciding what topics are debated? Because I've done a lot of Edge scoring, right? And I don't know if the same principles apply. Do you have to do a lot of research before you set motions? Are you still given some flexibility to decide what topics you would like to hear people talk about? Or are there specific rules that are just unknowns to us outside?
One of one of the things that we had to consider was requests, right? Like not requests from the participants, but requests from the administration, the school, basically the host. And this is more for marketing purposes where we go like, see, this isn't just a useless waste of our time. This is something that can help us change the world. So for this year's PLDC, the theme was Roar for All. And the reason for that is we wanted to take a look at sustainable development goals. So a lot of our motions were directly tied to sustainable development goals. So that's one thing, requests. It's one thing to have a debate tournament because it's just like it's a hobby for a lot of these people. But for law debate competitions, a lot of people think, oh, I can actually put this in my resume when I apply for firms. So another thing is you ask for a lot of sponsors and stuff like that. So we need to be able to market to them by talking about this is the theme and we are actually like making good on the themes. We don't have to, right? But you're like, okay, you know what? Fine. This is something that's worth talking about anyway. So that's one thing. Another one is when all three of us in the Edge Corps were lawyers, are lawyers. So we often go like, oh, I'm kind of annoyed by this thing at work or
Mm.
like this thing is messing with my mind at work. So maybe we can make a motion out of this. So that's another thing. Like experience plays a big part in it. So obviously not 100% of the time, but sometimes you just read something on the news and you go like, oh, that would be an interesting debate motion for this law debate thing. But lastly, with respect to how much research should we put in it, and like so I suppose a corollary to this question would be, are there things that you could set in a law debate competition that you could never set in an ordinary quote unquote ordinary debate competition? The answer is definitely yes. So one is things that we expect law students to know or have read about or to easily read, but you would not expect any other person to have done so. So maybe something about a particular case, like 303 Creative LLC versus Elenis,
Mm-hmm.
right? I think that's the name of the case. What about the case that overturned Roe versus Wade? Or what about a case like Tan versus Tan Andal, which is about psychological incapacity? So those very specific things, right? That you need to expect a lawyer to have read or a law student to have read, but another person would not have read it.
Right. I remember in the tournament, PLDC, there was a different standard for judging as well, right? And if you're not aware, in tournaments, usually a judge has to assume the role of an average reasonable person. And I remember you had a different term for it for PLDC, right?
Average reasonable law student.
Law student.
Yeah.
Okay.
Uh,
My question there is, how do you decide like between a first year law student and a fourth year law student, right? Especially if you're talking about particular cases. Are like these cases usually discussed in first year? Do you have a significant advantage if you are a much older law student? Not just because of skill, but because of your access to these cases or these discussions.
Well, regardless, right? We give them a month in
Okay, yeah.
advance. So even if you're first year and you've never read this particular case, then, for example, right, we had one that was specifically about criminal procedure, about like how do you, not just criminal procedure, but also evidence. Like, how do you treat a situation where you get arrested and there's like a huge amount of drugs that are found on your person? Can you still say that those were planted?
Mm.
Right? So, those kinds of things you don't take up until later on in your life in law school, but a lot of the principles behind them you learn in first year anyway. So, one of them is, even if you don't know the specific case, you probably already know the principles behind those cases. But secondly, if you don't know either of them, you still have time to actually read up on them.
Okay, okay. So I guess now I want to ask about specifics. This first half of our discussion so far has been sort of meta, talking about how the circuit works in law school, what are different considerations. But now I want to talk about like the actual debates and arguments that one might run. If you don't know, right, as an audience member, not you, Kyle, but as someone listening, in most debates, we usually assume a particular mindset, right? Most of the time, we are arguing for progressive values. There is a baseline. Like, we're not allowed to say things, for instance, that, you know, people in the real world might say, like racist thoughts and weird Ben Shapiro ideologies. But in debate, those are somewhat curbed or limited. What I want to ask is the baseline different in law debates? For instance, a lot of principles in other tournaments are debatable, but is there a different mindset or is there a lower threshold when we are discussing law debates, especially since we do have a lot of conservative decisions that can end up being legal basis?
I think it's a higher threshold because you can't just say, oh, this is a progressive value and then call it a day,
All right.
right? You have to defend it against. So we assume that even a conservative view might be valid if you reason it out well, or you don't necessarily need to defend the conservative principle per se, but defend the process of getting there as something that's valid. So one example is in the semifinals, one of the motions was this house to decriminalize abortion. And so you would not typically see that in a quote unquote ordinary debate tournament because, yeah, why shouldn't you? Right? Like, there's a patriarchy, women's bodily autonomy gets, like restricted all the time. So why wouldn't you decriminalize abortion? But in this debate, it might be difficult if you are a college debater who's entering into this tournament going like, oh, this is just like a legit debate. But there is a very, very strong legal argument for why you should not decriminalize abortion, at least in the Philippines, because under the Constitution in Article 2, which is the Declaration of Principles, it states there that the state will protect the life of the mother and the unborn equally. So, and as explained in the case of Imbong versus Ochoa, life begins at conception and fertilization. So, we need to protect the unborn from the moment that it gets fertilized. So, the question now is, can you defend the Constitution in this particular way for this particular case? And opposition, I think, was able to by saying that, okay, look, you might think that it's moral for us to do this, or you might think it's moral for us not to do this. We don't know. The thing is, we can't impose our personal idea of morality on everyone else. That's the reason why we have a democracy. And in a democracy, right, we have an approximation for what's moral based on democratic values and through the democratic process. And the ultimate manifestation of that is the Constitution. So if, like, even if you might personally disagree with that provision of the Constitution, it doesn't matter because legally you're beholden to it. So, and then you can do the typical debate or arguments about, like, oh, why is it just from a logical point of view, the life of the unborn is equal or in some cases even greater than the life of the mother? And these are the things that I personally do not agree with. But if you're a law person, this is something that you might find compelling just because there's like very solid legal basis behind it.
So my question now is, because like the Constitution seems to be one of the main tenets that all laws are subject to, how do you government that case, right? Like, if there's a strong legal basis in the Constitution that says life begins at conception or fertilization, doesn't that leave very little wiggle room for proposition to argue, especially if they're forced to argue against the Constitution?
Well, I think in that case, I think proposition kind of missed an opportunity to narrow the debate down where you can say like, okay, we know that this is not in the Constitution or this is not allowed in the Constitution as it is today. But this debate is also about whether or not we should change the Constitution. So that's all of the things where, okay, I mentioned earlier legal basis, but there are some cases where you don't necessarily need legal basis in order to have like a strong case. And in those cases, one of the examples that we put in the rules was if the question in the debate is about whether a particular policy or a particular provision of the Constitution should be retained or not. So if that issue was raised very early in the debate, we might have seen something different as the debate went on.
Okay. Now, I also wonder what the mindset is when you enter a law debate, because, and this is a discussion Kyle and I have all the time, right? I'm not the type of debater that will use examples and then try to find arguments in them. I'm more of the other way around. I will think of logical arguments and then I'll look, if I have time to look or if I'm allowed to research, that is, I will find examples or evidence to support my claim. But Kyle is the opposite, right? A lot of their arguments are informed by matter, are informed by evidence and research. And they kind of center a lot of their ideas on that. I'm not saying this all the time. Okay? I'm not saying you do this all the time. But in the greater scope of things, that seems to be the trend you do. In a law debate, would my style still fly? Or do you think that law debates benefit more from like gathering as much legal basis as you can?
Well, again, it depends on the format that you're in. If it's just like a debate, like the three versus three, I guess it'll be fine to do the thing that you do, and you know that it's fine because for people who are listening and they don't know, Nina once did swing for a law debate tournament, and not only did Nina do very well, she went perfect break and was the best speaker of the tournament, even though she was a swing team and did not have any legal background whatsoever. So Nina already knows that the style can fly, right? But there are some instances where you really, really, really need to gather as much as you can before entering. So one example is moot,
Yeah.
where you never know. Okay, so for people who don't know, moot is like you have extended speeches. It's not just like 7 minutes, it can be 15 minutes, it can be like 9 minutes. You are given a certain amount of time per team. So let's say there are two of you who are going to speak and you have 30 minutes. You can split it as like, okay, I am going to speak for 10 minutes. My co counsel will speak for the rest of the time, right? And then the judge or judges can ask you any question they want at any point in your presentation. So you really need to know as much as you can about all the possible issues, about all the possible lines of questioning beforehand, because if they give you like well, okay, let's talk about this other thing, here's my question, you need to be able to answer that, or it'll be really, really good if you can answer that. So sometimes you need to go from the perspective of, okay, let me just use my logic and then fill in the gaps using research later on. But another part of it, in some cases, you might need to have as much in your brain as possible. And you have this argument, this line of argumentation, and you're filling it in, but you have so much stuff in your mind that you might not even be able to say because the questions might not come up.
Okay. Now I want to ask about specific ideas because while I was moral supporting for PLDC and I ended up doing like a bunch of errands and it was fun. Like no complaints. I just really loved and was fascinated by being exposed to something familiar but also not in the form of debate and law life. And I noticed that a lot of people seem to repeat some ideas, right? Like adhering to the Constitution is a really big one that a lot of people have discussed. Or another one is about like going back to the definition and like defining things and looking at how other people have defined it and using that same definition for uniformity and to adhere to some precedents. I now want to ask you because I know you prepared a few things for this episode. And you've been doing a lot of research, not just for law school, but also for PLDC. What are some arguments that you particularly like using or hearing other people discuss that you feel can apply to many debates? For example, in my career, I really like talking about impacting and how we help the most vulnerable, right? Like that's my go-to clash. And I feel like if I win that, if I weigh that, then regardless of what the other team says when it comes to practicability or necessity, I feel like if I'm able to prove who's the most vulnerable and how I help them, that's going to be my main ticket in different law debates. Would you say you have a particular silver bullet that you end up? Well, it's not always a silver bullet, right? A lot of
More
people
like a
think,
Swiss knife,
yeah, a Swiss
right?
knife or a basic idea that you find yourself going back.
There is a line, like not even an argument.
It's a
There is a
line.
line.
It's a line.
There's a quote
Okay.
that I've heard. I think every other round in PLDC and every other law debate round
Okay.
I've watched,
I'm
someone
interested.
always uses this line.
Okay, what is it?
And I think that you were talking about like the vulnerable,
Oh
the
my god,
vulnerable, the vulnerable.
you are teasing me. What is the line?
It's those who have less in life should have more in law.
Oh.
This is from Ramon Magsaysay, and this is the way that we conceptualize social justice. So there's a lot of precedent for saying like we need to protect the most vulnerable. Although like formally the Supreme Court never said like this is what social justice is all about. They also just quote it because it's a really quotable quote.
Yeah, I
Like,
agree.
but as far as I know, the formal definition for social justice is like, oh, it's not tyranny of the majority. It's not, it's not nihilism. It's not socialism. It's just the greatest good for the greatest amount of people. And I remember in first year, I read that, and I was talking to some of my friends who had a background in philosophy or development, and I was like, that's a weird definition, right? Because that's just utilitarianism, isn't it? And they were like, yeah, it is just utilitarianism. So I think like it's more compelling to just run away with the quote and just go like, those who have less in life should have more in law. And this is the basis for our conception of social justice today. Like that. So you can use that in many, many, many debates already. Right. So that's one thing. Another thing that I think shows up a lot is this concept of due process or maybe even equal protection. So equal protection for people who just read the Constitution, it's like no one should be denied equal protection of the law. Most people, many people think that that just means that the law should treat everyone the same way all the time. But that's not necessarily true. The law does allow for reasonable classification. So that's to say, you can be treated differently as long as you are substantially different from another particular class. So, for example, people in the government have higher responsibilities. And the reason for that is like, well, you are different compared to just any other worker. Like you are representing the people. The money that's paid to you is people's money, so you need to be extra responsible. So there is a little bit of discrimination in the law, and the law allows for that as long as it is based on real and substantial differences. But there are some cases where you fight about whether this is a reasonable classification. For example, in the United States, there used to be a military school that's just for women, and another military school that's just for men. And so the question there, from an equal protection point of view, is was this a reasonable classification? Can a woman join the all men military school? And the Supreme Court of the United States said, yeah, there are some women who there are some women who can make it in the all male school, and we can't discriminate based on sex here. So the the defense of Virginia, that's the state that we were talking about, their defense was basically saying like there is a substantial difference between men and women that we need to respect and protect. So women tend to not be able to undergo the same rigorous training in the all male school. And the question is, okay, fine. In most cases that might be true, but what should the law's position be? Right. And so one of the things that I've been very into lately is Lincoln.
Mhm.
Right. So you know this, Tita. I have like
I know it too well.
yeah. So this is because one of my father's favorite movies is the 2012 film Lincoln. And this was about the process that Lincoln had to go through and all the dealings that he had to make in order to pass the amendment to the Constitution that banned slavery. And one of the characters there was a radical. And people were asking him, oh, so you think really that white men are just equal to black men in all instances? And there was a lot of pressure from the more radical camp to make him stay true to his principles and say, like, yes, they are. They are, in fact, equal. But it was more strategic for him to just be legalistic about it and talk about we don't have the right as the government to decide who is equal or not. So we just have to assume that everyone is equal. So he says that I'm not saying that everyone is factually equal to everyone else, but they should all be treated equally under the law. So that is something that I take with me every single day of my life,
Mhm.
where I'm like, is this a reasonable classification? Like, am I because we always talk about like, oh, that's a double standard, right? So one of the things I talk about whenever that comes up is this a reasonable classification I'm making? Is the basis of the distinction something that is related to the purpose of the law? Like, if the purpose of the classification is to protect women, would treating women differently be germane to that purpose or not?
Okay. I feel like we should wrap up soon. And I have one final question for you before we end, right? Which is, I'm sure a lot of people who join debate, myself included, like a long, long time ago, before I changed my mind, they have intention of going into law. I feel that very traditionally people see law school and debate as very complementary to each other. And I agree, right? If you practice critically thinking about issues, see both sides, and it does help you in, you know, discussing the law and even criticizing it. What's your advice to debaters who might want to join or enter into law school and are using debate as one of their tools to better themselves when they do get into law school? What should they focus on? What should they keep in mind? Stuff like that.
So there are lots of principles in debate that you can carry over into law school. Like we need to protect the vulnerable, and we need this whole thing about let's study about politics. This will be very helpful in your first year when you talk about constitutional law one, which is about the structure of the government. So that's one. Another thing is if you do arguments about criminal justice, like the principles behind why you have criminal justice, that will also be very helpful. So I remember in first year during mock recitation, the professor was like kind of snarky about it, where he was asking, "Do you even know why the title of the case is People of the Philippines versus I don't know Kyla Tega?" And like people didn't know how to answer that because it wasn't in the case.
Mm.
So a lot of the things that might be asked of you are not found in the case, but you can find in just like debate arguments.
So, what's the answer there? Because my guess is like, to break a law is to harm the entire country and the people in it.
Yeah, exactly.
Oh, okay.
Yeah.
Great.
And this was something I learned debating as well,
Mm.
right? That's the reason why it's people of the Philippines versus Kyla Tega. It's because the real party in interest, the real victim here is the people of the Philippines because you disrupted their right to peace and order.
Their social contract with the
Yeah.
state,
Your
basically.
the social contract with the state. That's
Mm.
another thing. So that's one. A lot of the concepts, at least the principles, you might learn from having an extended debate career. But secondly, just in terms of like the way that you conduct yourself in high pressure situations where someone asks you a question and you need to logic your way out of it in 5 seconds. Otherwise, you're going to fail that class for the day.
Or, embarrass yourself in court if you make it all the way to passing law school or
Yeah, so
something.
you need to be comfortable enough to reach into your memory palace or whatever at a moment's notice. Sorry, mind palace at a moment's notice and try to make an argument for why you're right or why the other person is wrong
Mm.
at a moment's notice. So I remember this. And another thing is, as long as you have the principles right. So, right, if you're debating, you think about, okay, so I know some principles that I want to run. I don't know where this is going to end up, but I can build on it with my logic. And there are some cases where you don't go to class completely prepared. Everyone will have to go through that. Everyone will go to at least one class in their lives where they're like, "Oh man, I did not read everything and I'm not confident in, reciting today." And you will also get unlucky and get called on the case that you did not read at all.
About to happen.
That happened to me. And so when that happened to me, the only thing that I had was the facts. Because okay, if here's something that they do in law school. They have these things called digests, which is just like a primer for the case. So they have here are the facts, here are the issues, how did the court rule on these issues, why did they rule on these issues the way that they did, and how did they reason it out. So on that day, I wasn't able to study for that class because right after that, they had a big exam, like directly after that. So I was relying on digests mostly, which is something that you should not do. Okay. For listeners, that's something that you should not do. As much as possible, read the case yourself, like the full text. And even if it's like hundreds of pages long, it's better for you to read it because, like, if you retain some of it, or at least the greater story behind it, it's much easier for you to spontaneously recite, aided with your notes or digest than not. So anyway, that time I only had digest, and the facts of in the digest were good, but the issues were weird, like the issues in the reasoning. So the first issue was, should this land be registered? And the answer that the digester put was yes, and put some reasoning behind it. And then the second issue is the same as the first issue, like, should this land be registered? But then the answer for the second one was no, and had like completely different reasoning. So I was like, nope, this is, I hope I don't get called on this. And I did get called on that case. And I did not understand how the Supreme Court actually ruled in that case. So I was just like, okay, let me just use the facts portion and then make up my own decision. And it turned out to be correct. Because one of the things that debate teaches you is you don't need to know everything. You will never know everything. But based on what you do know, the important things and logic, how can you predict what, let's say, a particular actor would do? So, on that basis, I made my own ruling. I said, the Supreme Court said this. So in my head, I was like, no, I'm saying this. And I still got a pretty
Kyle
good
is
grade.
you're the Supreme Court
I am the
now.
Supreme Court now. So yeah, that's another thing, right? Which is trust in the argumentation skills that you build in debating. Because there will be times when you are not completely prepared for this question. So you need to use your own logic. And even during the bar exam, we were told by a professor that, okay, there will be some times when you really don't know the answer. It's in those cases where you need to fight the hardest to be as logical as possible. So that's another thing. I'm sure that there are other, like, more things that I can tell you about the intersections between law school and debating. Let me think. Maybe next time.
Maybe next time. All right. I still have a ton of questions, but I feel like at this point they're hyper specific and we can save them for another time. And I'm pretty sure I will end up asking them in future episodes in one way or another, given how much we tangent together. So thank you so much, Kyle.
Thank you so much, Nina.
And with that, we will wrap up this episode. Thank you so much for listening. We'll see you in the next one. Bye bye.
Bye.